Good morning, namaskar, hello and welcome. My name is Bhuvan and this is the Indian Express Explained, where we take a look at the explained page of Indian Express and also a host of other news that is of prime importance to a civil service aspirant. Right, let's get started. The first topic that I have for you today is again from the Express page of Indian Express, where we are going to take a look at the rights of divorce or the divorce mechanisms that are in place in the Islamic faith. Right, that's agenda number one. Let's get started and not waste much time here. This is where you're going to go ahead and connect with me if you have any questions related to what we discuss here today. All right, this is the Instagram ID. Go ahead and scan this and become a part of my Instagram community. Right, without wasting much time here, let's get started. The first topic that I have for you, as you can see, before Supreme Court today, the question of law in Muslim women's right to divorce. This is going to be examined today by the Supreme Court. The second topic also, in fact, is a development that took place in the Supreme Court yesterday. So a host of very important judgments coming out, and obviously the policy implications of that will be immense. We'll also seek to understand that, right? Revisit, Coder, Surendra, good morning guys. Thank you for joining. Thank you so much. Right, let's understand this now. So what is Supreme Court going to do? It will examine a 2021 ruling of the Kerala High Court regarding khula. Okay, first thing, this is what the Supreme Court is going to understand. What is khula now, you might ask. So what is khula? The right of a Muslim woman, and here is the key word, to unilaterally divorce her husband. Okay. So when you look at the, say, divorce mechanisms in the Islamic faith, okay, there are 3-4 more mechanisms that we need to just have a cursory idea about at least, and say understand what are the rights being impeded, or what is the, say, consequence of the recent amendments that have been introduced in the House. You know, if you have been aware, recently triple talaq was abolished. So you had that amendment that was introduced in the Parliament, passed by the Parliament. So what does the implication of that happen? Please understand this, that divorce, we are looking at two forms. Okay, two forms of divorce is what is you are looking at. Number one is the judicial way, and the next one is the extrajudicial way, you know. So the judicial way is you go ahead and say approach a district judge, okay, and then you go through the whole procedure, and then eventually a decision is arrived at. That is a judicial way of obtaining or, say, getting divorce. But what is the extrajudicial way is what is of prime importance to us. So let's understand that. Okay, extrajudicial divorce, those that take place without the court's intervention, obviously. Okay. Now, in the Muslim faith, in the Islamic faith, what you find is that you can have, say, quasi-judicial representative, say a qazi. Okay. A qazi can be considered to be a quasi-judicial body or an authority who could be in charge of this whole process. Okay. So let's understand that now. Whether Muslim women lost the right to extrajudicial divorce after the passage of the Dissolution of Muslim Marriages Act 1939. This is the question that is going to be looked at by the Supreme Court. Okay, that did this dissolution of this particular act, did it take away that right to, say, give khula to their husbands? Okay, so let's understand what exactly is khula now, one by one. Firstly, like I told you, it refers to the right of a Muslim woman to unilaterally divorce her husband. Now, similar to the right of talaq conferred upon Muslim men under Sharia law. So if a Muslim man wants to go ahead and divorce a Muslim woman, then you're looking at, say, talaq. And if a Muslim woman wants to go ahead and, say, divorce the husband, you're looking at khula. Now please understand that in the Islamic faith, marriage is to be seen as a contract. Okay, it's a contract, which means that there are certain obligations, right? And because you have obligations, and if you do not meet those obligations, then the contract can be nullified. Okay, this is the first important thing that you need to understand. Okay, if I were to just draw a rough flowchart for you, this is what it would look like. That in the Islamic faith, you're looking at marriage as a contract which has certain obligations that has to be met, and if they are not met, then, well, the contract can be nullified. Now, the recognition of khula that we are discussing, where does it get its legitimacy from? So you find that the mention of it is in the Holy Quran, right? Now, please understand two parts here. The nullification of the contract, which means that there are two parties, okay, party A and party B. Do both need to agree for the contract to be nullified is the question first. Correct? Is that how not a contract works? Say I have a contract with you. Now if you want to go ahead and break the particular contract of whatever terms and conditions that you have set or we have agreed upon, okay, can you unilaterally sever the contract? What is the terms of severance of the contract is also a question that is going to be looked at. Okay, so there you find that there is no clarity about the manner in which khula has to take place. So whether you need the husband's consent or not, after all, it is a contract, right? So that consent question of the husband is also to be explored by the Supreme Court. Now, let's go ahead and understand the comparative analysis of different types of, say, divorce that takes place in the Islamic faith. Okay, first one you have talaq-e-tafweez, which is again a contract-based divorce. Now, look at this very carefully. If a husband violates any condition agreed upon at the time of marriage, you see, is this not what a contract is? That the obligations are not being met, and thus you find that the grounds for divorce are now absolutely agreeable. Okay, the wife will be entitled to divorce without the court's intervention. Extrajudicial, which means. Okay. Now, what is the consent here looking like? Consent should be reasonable and not go against public policy, which means if a husband and a wife, and if the husband goes and marries someone else, well, he needs to have the permission of his wife, right? Only then will that marriage work, or else grounds are there for divorce under talaq-e-tafweez, right? Next, we have mubarat, which is again a separation by mutual consent. See, the contract getting broken, both the parties agreeing, yes, let's sever the contract. Done. Mutual consent. So you find both Shia and Sunni sects, they deem this form of divorce to be irrevocable, which means it cannot be undone. It's a chemical change that takes place. And finally, you have fasq, which is a divorce through the intervention of the court or an authority like a qazi, which means judicial plus quasi-judicial. Both are a part of fasq, right? Third party intervention is here. Now, there are the points of difference. Let's understand the points of difference one by one. In talaq-e-tafweez, will you agree that it is unilateral, right? That if you have a particular condition that is violated by the husband, then you find that the wife may go ahead and break the contract under talaq-e-tafweez. In terms of mubarat, it is mutual. Correct? Is it not mutual? Tell me. Right? That both parties are agreeing that yes, we should go ahead and sever the marriage, break the marriage. Yes? And finally, you have fasq, where you have third party intervention. That they're unable to come to an agreement, and thus you find that either a judicial body or a quasi-judicial representative is in charge of this process. Correct? Bulbul, good morning. Shesh, good morning. Okay. So these are the types of analysis that we have done. What is important for us today is to know about khula. Okay. Now let's understand the timeline of this entire story. So what you find is that the Shariat Application Act 1937, this was the first one that came into being, and this recognized both judicial and extrajudicial divorce, which means district court and qazi. If you went ahead and got your divorce through these two means, yes, that is agreeable. Okay. But fasq was not recognized. Now again, to revise for you, what is fasq? The right of a Muslim woman to unilaterally divorce. So this unilateral question was negated by the first law that was put forward, the Muslim Personal Law Shariat Application Act 1937. Okay. Now what you find is, despite the existence of the Sharia Act, you had particular schools. So the Hanafi school did not agree to this. Okay. They said, no, this is not agreeable to us. So thus, this was carried forward. Next, you had after 1937, you had 1939. The Dissolution of Muslim Marriages Act, which extended the right of extrajudicial divorce to all Muslim women, basically to solve this problem. Right? This was the whole issue that it wanted to go ahead and address. And then there were grounds that were laid down as to on which conditions can women go ahead and get divorce. So adultery being one, or say impotence being one, okay, or say any form of those manners which goes against the public policy, the agreeable part of what is a civilized society. If any of that were to be broken, well, that is ground enough for for a Muslim woman to go and seek divorce from her husband. Okay. So now, recognized the FUSC route of divorce. So the first time you had FUSC that was recognized was in 1939. But then there was a development in 1972. You had the K.C. Mohsin and Nafisa and others case which negated the Muslim women's right to invoke extrajudicial divorce. You see. Thus you found that the Supreme Court and even Kerala High Court then observed that the point of these acts, in fact, it went ahead and termed this particular act as a bad act. Okay? As a bad act. It's a bad law. Okay? And it said that the whole point of this the point of this policy is to give the maximum width to conserve and protect the rights of Muslim women. Okay? And thus, a bad law cannot go ahead, a bad observation cannot be used as an excuse. Right? So this is the entire story which the Supreme Court is looking to tackle in today's hearing. Okay? Whether, say, FUSC is firstly a primary part of this entire divorce process. Okay? Do you need the consent of both the parties, especially the husband, because FUSC is unilateral? So do you need the consent of the husband if the woman wants to go ahead and unilaterally divorce her husband? Okay? So these are the primary questions that the Supreme Court will look to tackle in today's hearing later in the day. Right? Now let's go ahead and look at few questions that I have for you. So which of the above are grounds for divorce in India? Okay? Now this is again not related to any particular community. So the general acceptable grounds for divorce. So for example, today you were to go ahead and say completely renounce your worldly pleasures, become an ascetic or a yogi, okay? Someone who is say devoted to his or her faith, is that a ground for divorce? Is renunciation a ground for divorce? Yes or no? Okay. Adultery, relatively easy. Is it a ground for divorce? Yes or no? Imprisonment. So what happens if one partner gets say a life imprisonment? Will that be construed to be say unjust on the rights of the other partner of the marriage? Is that grounds for divorce? Yes or no? That's what you're going to answer for me. And alcoholism, a problem prevalent across different levels of the society and strata. So can that also be construed to be a reasonable grounds for divorce under the say rules of mental torture on the other partner? Okay, you are going to go ahead and answer these questions for me. Which of the above are grounds for divorce in India? Next, khula, is it mutual consent? Mubarat, do you need the consent of one partner? And FUSC, do you have an external authority that goes ahead and negates this process? Okay, which of the above is or are incorrectly matched? More often than not, I find that students do not look at this part correctly. Yes, I ask the incorrect one, they answer the correct ones. Make sure that you have an SOP in process when you're solving a question. Here is what you can do. Firstly, look at the problem statement. Okay, thereafter look at the options, and thereafter look whether you are supposed to solve the correct or the incorrect bit. For each and every question here on, have this SOP in place. Unless you're not following this SOP, you're much more likely to make that mistake of incorrect or correct. And bear in mind, one single error on the final day could probably decide your future, your entire year, your entire career. So have a particular strategy and SOP in place whenever looking at solving an MCQ. Okay, this is one way that you can go ahead and try. Right, you will let me know your answers in the chat box for the questions that I have for you today. Meanwhile, before I go forward, very quickly, this is starting on the 23rd of October 2023, an early morning batch. If you're preparing for 2024, 2025, 2026, this is the course you sign up for. Everything is covered online, plus the entire scope of the syllabus, right from say from the prelim stage up until the interview stage. Okay. All of the paraphernalia that you expect, the daily handouts, the answer writing, yes, top class material. More importantly, you have excellent teachers, and I'm not browbeating my own, I'm not, speaking highly about myself, not at all. I'm saying as part of a tight-knit community here, the teachers here, The individuals that I work with, extremely talented individuals, committed individuals more importantly. You can go ahead and connect with those teachers or those students who are already a part of this process, and they'll tell you for yourself that the entire focus of this exercise is to go ahead and build your concepts, build your question solving ability. Rote learning can only take you that far in the UPSC preparation, right? So go ahead and sign up for this. I think the last date is coming ASAP, right? And when you do decide to sign up, please use this code. Yes. Not that I stand to benefit anything out of it, but you do get a very good discount. And more importantly, I get to be associated with you when it comes to, say, current affairs, geography, international relations, CSAT, and environment, right? So let me know how many of you are signing up for this. You'll find the description box, the link in the description box below. Right, let's go to the second very important topic that I have for you. And look at this. The question, in fact, this article came in the Indian Express a couple of days ago. But the final decision on this came yesterday, okay? And so I thought it was most apt that we went ahead and discussed this in toto, right? So the Supreme Court now, yesterday, adjudicated on a particular case. Now the case is a little complicated, so bear with me and understand this. The petitioner is a mother of 2 children, okay? It's her 3rd child, an unwanted pregnancy. She wanted to go ahead and get the abortion done, okay? But the problem was that under the Medical Termination of Pregnancy Act, which basically governs the rights of the mother as well as the unborn child based on, say, different stages of the pregnancy, she had crossed the minimum threshold. What are the minimum thresholds? What are the ethics questions that can come out of this? We'll take a look at it more importantly. But understand the case first. Okay, that she had crossed the maximum threshold under which abortion could be allowed. Now, she claimed that she did not have, she was not financially well off. She was suffering from depression, had, say, mental health problems, and thus she be given the opportunity or be given the permission by the Supreme Court to go ahead and undertake this medical termination of pregnancy, right? So let's look at the facts of the case. Now I've given you a basic overview. Let's look at it one by one. A case on unplanned pregnancy. Now look at the time period. This is key here. 26 weeks. Okay. 26 weeks is when she went ahead and approached the judicial organization, the judicial organs. Now it came up before the Supreme Court. Petitioner has 2 children, does not have financial resources, plus has mental health problems. Okay. So now, unwanted pregnancy due to failure of contraceptive methods is the same as forced pregnancy, now for which termination is allowed up to 24 weeks. So in case of, say, unwanted pregnancy or forced pregnancy, in case of, say, a rape or of a minor getting raped and thus bearing a child, all of those special conditions, you'll find that, well, you're allowed to go ahead and terminate the pregnancy because, again, that is construed to be forced on the woman, right? Now the AIMS doctor, so when this case came up, the Supreme Court referred it to the AIMS doctor and said, well, what's your opinion? Okay. So the AIMS doctors, they said, well, the directive will be needed from the Supreme Court on whether feticide, which is the killing of a fetus, okay, can it be done before the termination of the pregnancy since the fetus is currently viable? Now please understand this, that after 26 weeks, which is the maximum threshold, okay, are you allowed to go ahead and terminate your pregnancy? Absolutely yes. You can go ahead and terminate your pregnancy, but certain conditions need to be fulfilled. And what would those conditions be? So for example, if the fetus or the unborn child has certain medical deformities, medical conditions that may directly threaten the health of the mother, in that case, you will find that on a case-to-case basis, permission may be allowed. Okay? But here, the problem was different. Here you find that, well, the fetus is viable, which means there are no medical problems, none associated with it. Okay? And it presents a strong possibility of survival, right? So it was obviously going to be a normal delivery or a normal child was being, say, in process. So now these conditions as claimed by the mother, right? Now you are looking at the Supreme Court having to decide, if you were to just analyze this, forget the facts of the case now. If you were to analyze this, can you agree that this is a case about, say, the rights of the mother versus the rights of the unborn child. Can you agree there? Right? So this is what the Supreme Court has looked to answer also. I know it's a very polarizing question, but you will find that in the Indian context, we favor one over the other. Okay. Internationally, there is some other definition. The Indian version is slightly tweaked, again, because of transformative jurisprudence. We'll understand what is that. Okay. So the Supreme Court bench, led by the Chief Justice, has decided on this question yesterday. This, if I were to just go ahead and break it down for you, it is the rights of the mother, okay, versus that of the unborn child. So which takes precedence, considering that the unborn child is healthy, okay, it is going to survive. If that is the case, can the mother claim that because of, say, financial resources being less and mental health problems, can she be allowed to infringe on the rights of the unborn child by going ahead and undertaking a medical termination of pregnancy? That is the whole basis of this problem that was put forth in front of the Supreme Court. Okay, now let's go ahead and understand the abortion laws in India. Before I tell you about the, say, history of abortion laws, because again it has come a very long way, okay, I'll give you a brief understanding of the history of abortion laws in India also, if you were to go ahead and ever encounter a mains question for this. But let's understand the current scenario, okay. So the MTP, or the medical termination of pregnancy, now it lays down three particular stages. Stage 1, up until 20 weeks from conception, okay, it is allowed on the advice of one doctor. This is after the recent amendments that were introduced just before lockdown, in fact. One of the last pieces of legislation that was passed just before lockdown was enforced in the country. Okay, the MTP Amendment Act. So there you find that these were the amendments. The most recent amendments are here in front of you. So up until 20 weeks, you can go ahead and terminate your pregnancy, no problems, on the advice of one doctor. The moment you cross 20 weeks and you are in this particular zone, 20 to 24 weeks from conception, now you find that your right to seek abortion is now limited. Okay, and it is now limited how? You need 2 registered medical practitioners who will go ahead and will decide your case on a case-to-case basis, provided certain conditions are met. Because at this time, you understand that there is a concept that you need to be aware of, which is fetal viability. Okay. What is fetal viability? So in the US's definition, you find that as soon as the fetus has a heartbeat, well, it is considered to be a viable fetus. It's going to, they assume that it's going to translate and become a child, okay, an infant. So fetal viability is the primary concern here. So what are the conditions in which your right can be taken away? Forced pregnancy, women with disabilities, or change in marital status during pregnancy. All of these are the conditions based on which the 2 medical practitioners will take into account your case and give a recommendation to the court. Okay. And finally, you have from 24 weeks onwards, the MTP Act requires a medical board to be set up in approved facilities, which means only certain hospitals, AIIMS, okay, the major doctors, major hospitals of India, you go ahead, there is a board there that will decide and give its recommendation. Okay. Now, which may allow or deny termination of pregnancy only if there is a substantial fetal abnormality. Okay. None of these conditions matter then. None of these matter. Okay. Only and only if the fetus is now showing unviable signs. It has some say physical health deformities that have come into picture in the scans. Only then. And if it is going to affect the health of the mother, in that case you find that the medical board will say, okay, here is our recommendation saying yes, you may undergo the medical procedure. Okay. Now the Supreme Court has observed this, and this is a very important term, considering that in the polity questions, normally you find questions of these types that are asked today. So I suggest that make a brief note of it. Okay. The transformative constitutionalism. What does it essentially mean? It's a big word, but you need not get worried here. It essentially means that law in the society, okay, the laws that we frame, the laws that we implement, the laws that we apply on a population must be in sync with the times that they are in. You understand it in the simplest manner. When we had, say, the Make in India or the Atmanirbhar Bharat Abhiyan, okay, forget this topic. Let's understand it in the simplest manner. What does transformative constitutionalism mean? Okay, the simplest analogy. When we had Make in India or Atmanirbhar Bharat Abhiyan, the first step of the government of India was to go ahead and do away with obsolete laws. You found that many obsolete laws, British era laws, were done away with. Obviously, one part of it was to speeden up the process. Yes, too many laws, too many barricades, your flow of process is slow. Done, agreed. But more importantly, it is the concept that in 2023, you cannot apply a law that was drafted in, say, 1897. That's foolishness. Yes, the law should be in sync with the contemporary times, the expectations of the people. That essentially is transformative constitutionalism. A law must remain cognizant of the fact that changes in society have ushered in significant changes in family structures. Yes, that the definition of a family today is so different from the definition of a family, say, in 1950s, 1940s even. Today you're looking at nuclear families. Today you're looking at different, say, societal standards of morality as what was considered to be, say, in the 50s or 40s, right? So all of that has to factor in when you go ahead and, say, get into the process of delivering justice. That is the fundamental theory behind transformative constitutionalism. ठीक है? Bulbul, Logeshwari, good morning. Thank you for joining, guys. Now let's go ahead and understand the history of abortion in India, or the medical termination laws in India. Okay, so what you find is, and let me just write this one by one. So up until, if I'm not wrong, the 1960s. Okay, let me know if you can see this font all right, or let me use a brighter font. Okay, up until the 1960s, what you found was that termination of pregnancy, it was considered to be illegal in India. Okay, not allowed. So up until 1960s, this was there. In fact, you found that you could face imprisonment up to 3 years. Okay, 3 years of imprisonment under IPC was there. Right? So look at how, say, the law has evolved over time. 3 years of imprisonment under the Indian Penal Code was in place at that time. Finally, you had the setting up of the Shanti Lal Shah Committee. Okay, the Shanti Lal Shah Committee was set up. Now, this was essentially to go ahead and look into the matters of abortion. Essentially to go ahead and understand the question: does India need an abortion law? This was the question before the committee. Okay, do we need it at all? Now, understand this: 1960s, huh? So it's not very recent, obviously. So Shanti Lal Shah Committee's mandate was this. Now, based on the Shanti Lal Shah Committee's report, which said, yes, we do need a certain law here, the medical termination bill was introduced in the Lok Sabha. Okay, this came up, the medical termination bill. Now, this was passed by both Lok Sabha plus Rajya Sabha. Eventually, it became a law. Okay, thus it became a law. This was allowed in India. And at the same time, what you found was that this IPC, the 3-year imprisonment, yes, this was again, in terms of criminalizing this whole process, this was still in place. Okay, this was not done away with. This entire not done away with. And so you'll ask me how. So this definition changed from termination to miscarriage. If the miscarriage was voluntary, okay, if the miscarriage was voluntary, then the woman along with the doctor both could be prosecuted. Yes, normal miscarriages, no problem. But say if it was going to be voluntary, then you found that the woman plus the doctor both could be prosecuted. This was up until, say, you're looking at the year of 1972. Okay. Now this is when from 1972 onwards, then we had the Medical Termination of Pregnancy Act that came up. And eventually you found that that was changed, and the amendments that I'm talking about in 2021, the MTP Act amendments. Okay, this went ahead and changed my definition to say 20 weeks, 20 to 24 weeks, and 24 weeks plus. Now, do you understand the theory here? So, if this is my current structure, up until 20 weeks, you need one doctor. Up until 20 to 24 weeks, you need two doctors. And here you need a medical board. Okay? Here, no restrictions. Here, certain amount of restrictions. Here, only health. If this is what I am looking at, then you can go ahead and understand the case before the Supreme Court now. Okay? What exactly is the Supreme Court looking at? The Supreme Court is saying that, well, here you have a woman with 26 weeks of pregnancy, which means she's falling in this bracket, and no health problems. Okay? The problems she are claiming is of this category. Now, if you are the Chief Justice of India, the decision is quite easy. You need to have certain set criteria for such a sensitive matter like this. Correct? Which is why you found that Supreme Court goes ahead and rejects the woman's plea. No immediate threat to the mother's life, no fetal abnormality. Okay? The two things, the two criteria only under which above 24 weeks plus you can go ahead and allow MTP. Okay, the medical termination of pregnancy, or also known as abortion, right? So thus you found that the Supreme Court does not allow this. It says there is no immediate threat to the mother and it is not a case of fetal abnormality. Why? Because these are the only two exceptions that a woman is given when it is gone 24 weeks plus of pregnancy. Look at this observation by the Chief Justice. Okay. AIMS doctors say she will have depression even if she delivers tomorrow. This is not a case of a minor victim. She is a married woman who already has 2 children. What was she doing for 26 weeks? That she claimed that her postpartum depression from the second case does not allow her to be in the right mental state to bear another child. And so the Supreme Court agreed with that okay, you are going to have depression anyways. That is, say, considered to be a part of the process. But if you were undergoing a particular, say, medical condition, where were you for 26 weeks? Why come now? Yes, because you have crossed this particular time limit, right? So this is the whole observation that you need to remember, that above 24 weeks, only two conditions in which you are allowed to go ahead and terminate your pregnancy, if it is fetal abnormality, and number 2, if it is going to affect the health of the mother. Okay? Clear? Got this topic? Okay. Now, the one more topic and one more, say, concept that you need to be aware of here is in the international arena. What is the chat not working, guys, today? I can't hear you. I can't see your chat. Anyways, let me know. If you're understanding this, let me know very quickly. Pradeep, good morning. How are you? Okay. Now, let's look at this in terms of, say, the Indian context very quickly. Then I'll take you forward to the questions that I have for you. So, in the Indian context, when you're looking at the rights of the mother versus that of the child that we are discussing here today, or the fetus. Okay. So, which one does the Indian context or the Indian legal framework favor? Okay, that we need to understand here, right? So, let's understand this. In the Indian context, firstly, what you find is that the fetal viability is being referred to as that stage where it has a heartbeat and it can survive outside the womb. So, understand this very quickly now. The fetal viability that we are talking of in the USA's context and in the Indian context. Okay, here as soon as you have a heartbeat, it is considered to be viable. In the Indian context, heartbeat plus ability to survive outside the womb. Okay, outside the womb. Which means what? This is earlier in case of the United States' definition. Okay, in the India's case, the time period is little extended. In the United States' condition, you have a very important case, the Roe versus Wade case. Okay, extremely important case, which has in fact up until this date, you will find that this case has become a primary concern area for the women of United States. Okay, the right to choose You'll often see this conversation of pro-life and anti-life. Not anti-life, pro-life. So it's essentially to do with the right of the woman to choose and say govern her own body. Should that take precedence over the rights of the unborn child? In the Indian context, what you find is that we go ahead and have a certain preference. We give preference to the rights of the woman. Okay, but these rights are limited as with time period, but they are given precedence over that of the child. Okay, this is the concept that you need to be understanding here. Okay? Is this very clear, guys? Right, this balance that you have to obtain between a woman's right to choose and say the perceived, in fact, rights of the fetus, right? There's a complex interplay that you will understand that is happening between the reproductive rights and the, say, protection of potential life. The reproductive rights versus rights of potential life, because once again, let's realize it's still a fetus. Okay, so rights of potential life. This is the conversation that happened in Supreme Court yesterday. The petitioners, say, counsel, the lawyer, it argued that Article 21, where you have, say, the right to life guaranteed, that essentially is a part of this conversation. But then the Supreme Court stuck it down saying, well, you are looking at a more wider definition. What we are more concerned with is, say, the time period limitations that have been crossed. That as soon as you cross 24 weeks plus, then there is a certain set criteria that is laid down, and only then can you go ahead and terminate your pregnancy. Okay, very, very important topic. Once again, I suggest you take a look at it exhaustively, because the questions that can come out of this are varied. Okay, I have tried to go ahead and give you 2 questions here. Let's look at this. Question number 3, part A. Termination of pregnancy up to 20 weeks requires no advice or opinion of doctors. And statement B, prenatal gender screening is allowed in India on certain grounds. Identify the incorrect statements. A only, B only, both A and B, none of the above. Prenatal gender screening is essentially knowing the gender of the unborn child as it is in the womb. Okay, are you allowed to do that on certain grounds? Right, this is the 3rd question that I have for you. And the 4th question, well, it's not an MCQ, but go ahead and give me 2 differences between, say, the definition of the rights of women versus rights of child and that of in India. What is different in terms of the USA versus India conversation? Just 2 points is what I'm looking at. Make it as brief as possible. That will tell me that you have understood it. The longer it goes, the person has not understood it. Okay, right. So this is where you will find the PDFs of this lecture uploaded. I upload it normally around 12 noon. Okay, go ahead and scan this, become a part of my, well, very fastly growing, in fact, Telegram channel, and I have only my students to thank for it. Thank you so much for your patronage. For those of you who are still not a part of it, well, we go ahead and engage in a lot of learning, discussion. Okay, and obviously the PDFs, the first information of all that is to come online from my side is posted there. So go ahead and connect with this. And if you're understanding these discussions, go ahead and leave me a like. Don't be miser with the like, guys. Yes, these are the minor happinesses that an educator gets. Don't deprive me of the minor happinesses, right? Okay, do leave me a like. I'll really appreciate it. Okay, the 3rd and final topic that I have for you is to do with rights. Not rights now, R-I-G-H-T nahi, R-I-T-E-S. Rights, which is now a Navratna company. Earlier it was a Mini Ratna 1 company. Now it has become a Navratna company. It is a PSU, by the way. It is a PSU under the Ministry of Railways. So Railways has many PSUs. The largest employer in India. So obviously it has many different organizations. Yes, you have the Indian Railway Finance Company that looks at, say, financing of these railway projects. Major money is needed. Yes, you have IRCON, you have IRCTC. You must have heard of IRCTC. You must have heard of CRIS, the ticket booking platform. Have you heard of this, guys? IRCTC to sabne suna hoga. How about CRIS? Or have you heard of IRCON? Have you heard of IRFC? And so many others. Okay. So Indian Railways, again, massive organization. It has many PSUs, and one of them, rights, which is to do with their rolling stock and their technological advancement. Well, now that has been promoted and now been classified as a Navratna company. Okay. So let's look at the things or the criteria that you need for a company to be now a Navratna company? ठीक है, curious? जय श्री राम, कैसे हो आप? Good morning, good morning. Okay, let's look at it. Navratna company के लिए क्या क्या चाहिए भाई? Number one, you should have firstly Mini Ratna 1 status. Yes, you are going to be promoted. Grade pay wise, it is the same thing. You can't go from say nothing to suddenly a Maharatna. Not possible. So you need to be a Mini Ratna, number one. Number two, you should have obtained an excellent or a very good rating in your Memorandum of Understandings, which means it should show that the governance of the organization is good, it's stable. Yes, corporate governance is how you go ahead and determine which company is good or which company is not good. Yes, how are the say shareholders? What is the division of shareholders? Who are the say promoters, the board members? All of that attach a lot of credibility. You know, does the company report timely reports? Does it release its timely reports? Or does it pay dividends to its shareholders? All of these are a part of corporate governance. So it needs to have at least a very good rating there, and it should report a net profit of 5,000 crore rupees plus for 3 consecutive years, which means financially stable. If you go ahead and fulfill these 3 criterias, you find that, well, you are going to be classified as now a Navratna. Okay, so it becomes, I think, Navratna, the rights becomes, if I'm not mistaken, the 16th Navratna. Okay, now Navratna status, what is the point? So okay, the company has gotten Navratna. Fayda kya hai usse? Number one, financial autonomy. You can go ahead and engage in mergers or say acquisitions up to a certain level. Okay, for example, if it is a huge value proposition that you have bought, you are going to get the Cabinet Committee of Economic Affairs involved. It is their permission that will be required. Eventually, you can't go ahead and burn public money. Yes. So therein is the accountability, the checks and balances that we talk about, guys. Okay. Eventually, financial autonomy is given, but only up till a certain level. And it can invest in international ventures without seeking government approval, only up till a certain limit, after which, once again, you head to the boss, the Cabinet Committee on Economic Affairs. Okay. This is to ensure accountability, transparency, and more importantly, you're dealing with public money. You know, so you need to have eventually the oversight of a superior body when it comes to say financial management, right? So this is the latest update. Rights, no more a Mini Ratna now, shall be classified as a Navratna. Okay. So I've given you the parameters on which it is going to have. The number of independent directors for a Navratna, at least 4 is what you need. 4 independent directors need to be present for a company to be classified as a Navratna. Okay. So rights becomes the latest Navratna. Go ahead. How many of the above are not a part of the PSUs under railways? IRFC, IRCON, IRCTC, NHAI. 1 only, 2 only, 3 only, or all of the above? You will let me know your answers in the comment box. And statement question 6. Positive rating status, net profit, prior classification as Mini Ratna. Which of the above are not necessary prerequisites to be classified as a Navratna? Not. Bear in mind. Don't make that mistake again, guys. Okay? Let me know your answers in the comment box. So that concludes this morning's discussion. Let's take a look at the questions of yesterday now. Yesterday we took a look at the partition of Bengal. Okay, 1905, 16th October, when the partition of Bengal took place. Yesterday was, well, one of those days when you sadly look back at a very crucial event in the history of India. Okay, so partition of Bengal in 1911 was done on administrative grounds is correct. It was done on administrative grounds, but eventually the intention was to go ahead and drive a wedge in Bengal nationalism. But the official explanation was administrative efficiency. And statement 2, partition of Bengal in 1947 was done on administrative and religious grounds. Unfortunately, not on administrative grounds, only on religious grounds. Okay, administrative grounds was not considered when you were going ahead and dividing, say, East Pakistan and West Bengal that time. Okay, so the incorrect statement here being B only. B only. Okay. Identify the correctly matched in respect of the Swadeshi movement. Pune, Bal Gangadhar Tilak, Chennai, Chidambaram Pillai. He in fact went ahead and acquired a shipping company. Yes, a shipping company was put forward by him in then Madras, now Chennai. Punjab, Lala Lajpat Rai. is correct. Delhi Ajit Singh is incorrect. In fact, Ajit Singh was with Lala Lajpat Rai in Punjab. So the correctly matched here being A, B and D. Okay, A, B and D. Okay, which of the following may not be considered to be a moderate leader? Firoz Shah Mehta, thorough moderate. Madan Mohan Malviya, thorough moderate. Surendranath Banerjee, petitions, writing, Kalam Ka Taakat, yes. But Aurobindo Ghosh, nowhere near being a moderate. He was someone who was the part of the Garam Dal or the extremists. Thus, the answer here being D. Okay. With reference to Swadeshi movement, PYQ, consider the following questions. It contributed to the revival of indigenous artisan crafts and industries, absolutely correct. National Council of Education, correct. Both being correct, yes. You eventually had this major thrust, guys. You need to understand this, that in Swadeshi movement, one of the major points of convergence across different sections of the society was to go ahead and indigenize everything, including education, cloth manufacture, companies, acquisition of infrastructure that was to be managed by, say, the nationalists, by our own people. That was the primary focus of the Swadeshi movement, And so a very rough parallel you can draw. If ever you are given, say, an essay to write on, say, the Atmanirbhar Bharat campaign, this would be a good starting point to start from. That the genesis of this idea, one can trace back to, say, the Swadeshi movement. So even though it came as a reaction to the partition of Bengal, the very conceptualization of the thought that yes, we will look inwards, we will generate our own momentum towards the creation of our own industries, our own education system. Why? Eventually, what was the point? To find that societies, that countries' place as opposed to the colonial powers. Yes. So in the essay, this would be a very good starting point to start from. It will have a very powerful starting impact. Yes. Again, it's just a suggestion. You can take it or throw it as you wish. Right? Let's look at it now. Paris Convention for Protection of Industrial Property. हाँ जी, है इसके साथ. TRIPS Agreement of World Trade Organization. Yes. GI tags are to do with both, in fact. Yes. GI tags have to be understood as a pan-global standard. Yes. That eventually someone sitting in, say, Mexico can go ahead and get my Darjeeling tea. Yes. Without needing to worry whether it is Darjeeling tea or the cheap Nepalese tea. Correct? Darjeeling tea, Mysore agarbatti, Govindo Bhog rice from West Bengal, Katarni rice from, say, Bihar, primarily in Bhagalpur, Mysore, Karnataka, all are part of GI tags, all of the above being the answer here. Right, so my star individuals, as I always mention in my class, Pranjul, Neeraja, Vidisha, Karuna, Koda, Pooja, Tanish, Revisit, Your Neighbor, Lekam. Lekam, thanks for your message, greatly appreciated. Aditya, Janavi, Ayush, Rahul, Akshay, Subhadeep, Preet and Robin. Excellent answers, guys. Okay, I don't think you guys had, anyone had at least even one wrong, which is very good to see, because it tells me that you're listening to the discussion very keenly and intently. More often than not, after you go ahead and listen to my lectures, to solve the questions, you will need at least 2 to 3 minutes of little bit of research. It tells me that you're applying yourself. To the rest of you, go ahead and engage with this process. Every morning, 8 to 9 a.m. is where we look at topics from the explain page and, more importantly, the question solving ability. Without question solving ability, you're cheating yourself insofar as the preparation for civil services examination is concerned. All right. So go ahead and engage with this. That's all I can go ahead and request you for. That concludes this morning's discussion. If you enjoyed the discussion, if you understood the topics, please do not hesitate to leave me a like. I'd really appreciate that. And with that, we'll call it a wraps. I'll see you tomorrow morning, 8 a.m. in the next class of Indian Express Explained. Up until then, this is Bhuvan Apurcha signing off. Wishing you a very productive day, a happy day ahead.